Good morning. Happy Monday. I've been watching, I think it's a series because this is the third one in a row that Juan Galt's posted videos about a Mark Stevens devotee who has decided that he wanted to run amok in court and get hung up on the idea of jurisdiction, that the prosecution has to prove to his satisfaction, not to the court's satisfaction, that the court has jurisdiction over him. Now, he says jurisdiction, and I don't exactly know what he means by jurisdiction because jurisdiction comes in a wide variety of flavors. There is territorial jurisdiction. That's the power of a state or a city to regulate within their territorial limits. For example, California can't make a law that makes it illegal to do something in Texas, generally speaking. I mean, if it affects California, maybe it does become, but it really has, the effect of it has to be in the state or in the city, whatever is generating that particular law. The other kind of jurisdiction that he could be talking about would be personal jurisdiction. That's power of the court over the person. Can you get the person into the court? Usually that's pretty easy to solve. There's just general personal jurisdiction, like you live in that particular state, or if it's a city court, if you live in that particular city, they have just general personal jurisdiction over you. Anybody can sue you in that county. So I live in Sacramento County. Anybody can sue me in Sacramento County, and I can't say that the venue is wrong, because then that would be the wrong venue, or it'd be a venue issue in California. That's how California talks about it, but it's still personal jurisdiction. That's what they're kind of referring to. And then there's specific jurisdiction, specific personal jurisdiction. That's like, say I'm traveling through the state of Texas and I happen to get into a car accident in the city of Amarillo. Well, whatever county that is would have jurisdiction over me for the purposes of that accident. I would have enough contact with them over that specific incident to allow them to exercise jurisdiction, personal jurisdiction over me. And then finally, there is subject matter jurisdiction. Subject matter jurisdiction is just which court gets to hear this. California's pretty easy. We have our Superior Court as the court of original jurisdiction. There are some administrative law courts that are courts of exclusive jurisdiction, I guess, technically speaking, for various matters, like workman's comp gets heard in front of a workman's compensation board, or a workman's compensation, ALJ. And then there are courts of appellate jurisdiction. So the courts of appeals in the California Supreme Court are courts of appellate jurisdiction. So it really doesn't make sense if you just say you have to prove jurisdiction. But let's just pretend, for example, that he was just talking about personal jurisdiction. In a criminal case, personal jurisdiction is pretty easy to figure out. Where did you commit the crime, and or where were you arrested for the crime? If it's something that is an ongoing crime, like, say, for example, possession of marijuana, a pound of marijuana, that at least at the time that this guy was arrested was a crime. It may still be a crime. I'm not up to snuff on my marijuana research. But he was driving through various counties, presumably, and it would have been a crime in each one of them. But he was caught in Napa County. So Napa County, because he was arrested for it there, or at least he was cited for it there, they would have personal jurisdiction over him, because that's where the ticket was issued. That's where they caught him for the crime that he was committing there in that county. But how do they prove it? Well, it's the same as with any other lawsuit. or with any other case. Criminal cases and civil cases both start out with allegations. That's all you have. There is a piece of paper that says, for the criminal case, there's the criminal complaint, or true bill, or whatever your particular city or state calls it. There is a piece of paper that says, on or about this date, at or around this location, like in this county, you did X, Y, or Z, and that act was a crime, or those acts were crimes. A civil complaint starts off with, in this particular location at this particular date, you did X, Y, or Z, and those were actionable torts, or they were otherwise things that I can sue over, or that I need non-monetary relief from, equitable relief from, like a temporary restraining order or preliminary injunction or a permanent restraining order, whatever it is. But they all start off with allegations. That is the way the law starts the process. And proof comes at the trial. That's where proof comes. The whole period between the service of process, the service of the complaint and summons, or the service of the criminal complaint, or what have you, however you're getting hauled in front of the judge, the time period between when you first receive notice that you're being sued or that you're being prosecuted and the time of the trial, what's going on there is discovery. That's where you're gathering evidence from each other and from outside. That's the evidence gathering stage. The prosecution in a criminal procedure probably already has the vast bulk of their evidence discovered before they get you in there, but they may not be done with it. But certainly the defense hasn't done all their discovery at the time that the arrest is made or the criminal summons is issued. So that time is spent gathering evidence. Now, in the Juan Galt video, the gentleman had filed a demur. A demur is like a motion to dismiss. In federal courts, it'd be like a 12b6, motion to dismiss for failure to state a claim. And what that means is that even assuming everything that the prosecution or that the plaintiff, even assuming everything they said in their complaint or in whatever document, charging document, even assuming everything is true in that, then there is still no cause of action. That there's still, if you filed a lawsuit against me saying that, John's a poopy head and I don't like him and I think his breath smells, well, then I could file a demur and say, even assuming everything you said about me is true, you still haven't stated any recoverable theory, any legal theory under which you could prevail. There's nothing in there. You can't get a temporary restraining order against me based on those facts. You can't get monetary damages from me based on those facts. So that's what a demur is. It doesn't require proof. Now there is such a thing as judicial notice in California. There's a few different ways you can get judicial notice where the judge, you don't have to prove, like, say, for example, you don't have to prove that Interstate 80 goes through Sacramento. You don't have to prove that. You don't have to prove that Interstate 80 and I-5 meet in Natomas. You don't have to prove that the city of Sacramento is in the state of California. Those are things that the court can take judicial notice of. The court can take judicial notice of dictionary definitions, maps, basically any well-known, like commonly understood concept that isn't being contested in the underlying action. The court can take judicial notice of. The court is required to take judicial notice of other things. The court is required to take judicial notice of constitutions and state or circuit. If you're in federal court, they're required to take judicial notice of stare decisis. California, they may take judicial notice, the court may take judicial notice of judicial proceedings in other states and the various papers that were filed in those other proceedings. And you can use those in a demur, say, hey, look, because of you taking judicial notice of these things based on what the plaintiff or the prosecution alleges, there's no crime, then you can use that. But that's the only real kind of evidence, in quotes, that you can bring in on a demur. So what happens is you get all the way to trial, and that's when things have to be proven. That's when, in a criminal trial, the prosecution has to prove beyond a reasonable doubt that you committed each element of a crime. In a civil action, that's where the plaintiff would have to prove by a preponderance of the evidence that all of the elements of whatever that tort are, or all the various portions of that the permanent restraining order that they need have been met. So it's at trial that you have the proof. So when he's walking in there saying that the prosecution hasn't proven jurisdiction, it can't prove jurisdiction, he's asking, number one, the wrong thing. He's asking it at the wrong time, and he's misunderstanding who the prosecution has to prove it to. Because all the prosecution needed was the allegation that he was in Napa County, and then the Napa County Superior Court has personal jurisdiction over him. That's all that had to happen there. That's the level of proof. It's just the allegation. Now, if it comes to light that he was at the trial, if it comes to light that the cop actually arrested him in Nevada, well, then the court's going to have to dismiss it, because there's no territorial jurisdiction there. There's no personal jurisdiction there. I don't even believe there would be subject matter jurisdiction, because a California Superior Court does not have subject matter jurisdiction over Nevada laws. So, but that comes at trial. All of that comes at trial. All the proof comes at trial. Allegations start it. Proofs finish it. Anyway, I hope that was informative. Thanks for watching. Have a great morning.